Yo, what up, guys? It's Derp with another video about the Iron Mace vs. Nexon court case. This one's going to be a little bit different in that I'm going to cover some of the bigger questions I'm getting in the Discord and in the comments of these videos. This is mainly just to help clear things up. Not really a specific timeline video or a specific opinion video. This is more of just a general what's going on in the court case to try to help clear some of this stuff up. So, to do that, I want to go over some specifics in relation to the Dark and Darker court case. These things are: what is this status quo that we keep hearing about? What actually is an injunction? What is the early case conference and when is it? And when do the injunctions happen? So, the reason why I'm doing this is because I want to let people form their own opinion of what they think is going to happen in regards to early access, when they think it might come out, and to kind of ease some people's minds as to the likelihood of everything happening, and to kind of give some hope as to and illuminate what Iron Mace might be doing. So before I get into the video, I do want to say thank you to everybody who's been subscribing to the channel, everybody who's been dropping comments and joining the Discord. You guys all rule. Keep it coming. I love the conversations. I love seeing your pictures of what you guys are working on and talking to you guys about all kinds of stuff in the Discord. Yeah, you guys rule. Honestly, the support is kind of mind blowing. My subs doubled. I'm already at 550. Hopefully, I could get to 1,000. Within the next month or two. The fact that I'm already almost at 600 subs is kind of huge, especially since I started doing this just to help out, the gaming communities that I'm in. Started with New World, and now it's Dark and Darker. So yeah, now I'm actually thinking that I can grow this into something cool. And again, thank you. You guys are huge inspiration to keep pushing forward with this. But let's get to what you want. Let's get in the video. So I'm going to start out with injunctions. What is an injunction? To be short, an injunction is a restraining order that prevents someone from doing a specific thing or seeing a specific person. There are generally three types: a permanent, temporary, or preliminary. And, I'm going to preface this with, I'm not a lawyer, this isn't legal advice, but I'm going to give you as much examples as possible and refer to, actual educational documents and government documents and even the Bar Association. So, according to Cornell law, an injunction is a court order requiring a person to do or cease doing a specific action. There are three types of injunctions: permanent, temporary restraining order, and preliminary injunctions. Temporary restraining orders, or TROs, and preliminary injunctions are equitable in nature. They can be issued by the judge early in a lawsuit to stop the defendant from continuing his or her allegedly harmful actions. Choose whether to grant temporary injunctive relief is up to the discretion of the court. Permanent injunctions are issued as a final judgment in the case, where monetary damages will not suffice. Failure to comply with an injunction may result in being held in contempt of court, which in turn may result in either criminal or civil liability. So, who, what, and when? And before we get into what it means, I kind of need to, we kind of need to know how many hearings Iron Mace is facing, when they're happening, and what they're about. So, first, let's go over how many injunctions there are. And as of a few days ago, Iron Mace is facing two sets of injunction hearings, one in Korea, one in the early case conference in the United States. They are both happening soon-ish. One in Korea takes place around July 1st. The one in the United States will be happening during the early case conference sometime in the next 30 to 60 days. But when are they? But what are they? These injunction hearings will determine if Iron Mace can release and charge money for Dark and Darker, or continue developing and servicing Dark and Darker while the cases are ongoing. They will also determine if Nexon has to stop sending out DMCA takedown notices in relation to Dark and Darker. This is because both injunction hearings have the same request in Korea and in the United States. Nexon is asking for the courts to ban Iron Mace from developing, selling, or servicing Dark and Darker entirely. Iron Mace is asking for the courts to ban Nexon from interfering with Iron Mace's business operations, including DMCA's. So, should Nexon win both of their injunctions, Iron Mace might have to shut down all sales, development, and operation of Dark and Darker entirely. If Iron Mace wins both of their injunctions, Nexon will be forced to stop interfering with IM's businesses until the court cases are settled entirely. This includes DMCA notices or any other kind of activity that would prevent Iron Mace from going about business as normal. However, both injunctions can be modified according to what the court decides is equitable and fair for consumers, as seen below. So, before I get to that, I want to get into status quo. So, let's kind of jump into this topic that's causing a lot of confusion with the status quo. A lot of people have been talking about it on Discord, on Reddit, in videos. But most importantly, and right off the bat, forget about that. It's nonsense. The status quo is a thing, but it's not really. So it's not important. In most situations like this, the most important things are the legality of the situation and what's good for consumers. The courts are going to do their job and uphold the law to the best of their ability while also protecting citizens and consumers from fallout of financial lawsuits like this one, ones that have millions to hundreds of millions of dollars on the line. They do not want to risk putting people in financial harm because of court decision. So the status quo argument for an injunction is a real thing, but it is a more nuanced and deep situation than how everybody on Reddit and Discord are using it. To be short, most people are parroting kind of what they hear on the internet and don't really have a clue what they're talking about. The judges care less about upholding some kind of status quo or what is currently happening with the situation of the product when considering an injunction, and they care more about the ramifications of said injunction on the businesses in question, and most importantly, on the consumer. With that said, let's get into some examples of actual injunctions in IP cases. And I'm going to use OnePeg as an example because OnePeg cited a great example of an injunction, how an injunction plays out with the Apple versus Samsung case. It's an IP case that's somewhat similar, except it's about a physical product. So while the case has a vastly different setting and situation, the premise is similar, and it gives us a good insight into what can happen in an injunction hearing. I have a link to their Wikipedia. It's just an easy way to link, and it is pretty valid. I fact checked the Wikipedia, but for the most part, this is correct. And here's what we know about the case. So in this case, Samsung had already released phones, tablets, and services that Apple claimed as intellectual property. It had little effect on Apple's actual market share in that sector of the market, and therefore the judge did not issue an initial injunction. The injunction, this is from the Wikipedia, the injunction Apple sought in the U.S. to block Samsung smartphones such as the Infuse 4G, the Droid Charge, and the Droid Charge was denied. Judge Koh ruled that Apple's claims of irreparable harm had little merit because although Apple established a likelihood of success at trial on the merits of its claim that Samsung infringed on one of its tablet patents, Apple had not shown that it could overcome Samsung's challenge to the patent's validity. So the patent itself, what may or may not have been valid, and people already had the product in their hand, right? So to place an injunction, a total restraining order would essentially mean that Samsung would have to go and recall these phones, right? And the judge was like, no, your patent might not even be valid. So we have to go to court on this to see what happens. I'm not going to force consumers to send their phones back in. And even if I tried, it's not going to work, right? So an appeals court later overturned that ruling and forced the judge to overturn his previous decision. So, and what they say is the preliminary injunction was granted on June 2012, preventing Samsung from making, using, or offering to sell, selling, or importing to the U.S. the Galaxy Nexus and any other of its technology making use of the disputed patent. Simultaneously, Apple was also ordered to post a $95.6 million bond in the event that Samsung prevailed at trial. They also weren't forced to recall or shut off services to all of the phones and everything that they'd already sent, but they were forced to discontinue sales and advertising in the US. Later, the courts then flipped the injunction again in a third appeal, uh, and Samsung was allowed to continue sales of the device and services. Following the trial, so this is the permanent injunction, following the trial in which Nexus was found not to infringe Apple's patents, Samsung filed an appeal to remove the preliminary injunction on October 11, 2012. The appeals court agreed and vacated the injunction. So that's the final decision. And what we see here is that Samsung released their product. It was allowed to sell their product for a while, and then Apple won the appeal. However, in order for the appeal to move forward, they were forced to offer nearly $100 million as a bond. This is a hold on an account to pay out to Samsung should Apple lose the case, and eventually compensate Samsung for lost sales. Once the case was over, not only did Apple have to pay Samsung that $100 million, Samsung was also allowed to continue selling their product. And their reasoning, well, the courts, like as in the court, well, the court decided that preventing damages to consumers was more important than preventing damages to Apple or Samsung, really, who could easily withstand the financial hardship. Therefore, the initial injunction was denied and then modified and reinstated. It's easy to assume that a similar outcome could be seen in the Iron Mace vs. Nexon case. Should Iron Mace release Dark and Darker early, especially if they release Dark and Darker before, or early access before the early case conference in the United States. Furthermore, the court will most likely consider the fact that Iron Mace will be placed under severe financial distress if Nexon's initial injunction is accepted in full. And this is regardless of the release of Dark and Darker before their early case conference or after. So the reason the initial injunction was overturned by an appeal was to allow, in the Samsung and Apple case, was to allow for both parties to have an equitable outcome that didn't interfere with the consumer. Remember, the consumer is the most important. Essentially, Samsung and Apple were both told to stop messing around and to do what's best for customers, while also preventing Samsung from, possibly breaking the law more than they already had, if they had at all. So customers got their product and continued to enjoy them. Apple had to stash $100 million in a court monitor account in case they lost, which they did. Samsung was able to sell a large amount of products and was not forced to offer refunds or shut off services before temporarily being restricted from selling said products in the United States, at least until the case was over. So they were able to sell a huge batch of them, made all that money, and then Apple actually had to put up, $95.6 million in order for Samsung to stop selling, because that's how much money they were probably going to make, right? So this ended up being a somewhat equitable decision that ultimately benefited the consumers and prevented Apple from moving forward with a frivolous lawsuit, unless they were willing to pay a hefty fine to Samsung should they lose, right? So if they didn't put the money up, their injunction would have been thrown out, right? If they didn't have the money, or they weren't willing to put the money up, they would have had to dismiss it, the injunction. So there's also another case that I've cited before that can be used as a good example, and that's NCSoft versus Bluehole. This is a article from the Escapist magazine. It's a little old. There's some other information, some other magazines and stuff, or e-magazines, news articles that are out there as well. But while we do have less information about this case because the U.S. case settled early, we do know that NCSoft was ultimately unsuccessful in getting an injunction. And this is in Korea. So this gives us some insight into the Korean injunction process. To start with, NCSoft was granted an initial injunction in Korea. However, that injunction was quickly overturned in full, which allowed Bluehole to release Terra globally. This led to NCSoft settling their United States lawsuit against Bluehole, or Bluehole's publisher, and Mass Entertainment. And then NCSoft later appealed the court's decision in Korean Supreme Court, and then lost there as well. So they tried to get an injunction against Bluehole 3 times. They lost once, won once, and then lost again. So NCSoft did win however, NCSoft did win their criminal case against some former NCSoft employees, with at least one going to prison for 2 years. I believe it's 2 years. Now that we know about the injunctions and their possible outcomes, we have kind of cleared the air about status quo. Let's get into when the injunctions actually happen, and that's during the early case conference. So what is the early case conference, and when will it happen? The early case conference, or ECC, as I call it, shorter, only applies to the U.S. court case. It is essentially a longer court session where they hold a lot of pretrial hearings and go over all of the rules, settings, timelines, possible settlement options, and other aspects of the case. This includes the injunctions. And it goes over dismissals, it goes over a long list of things. So, in short, it's a long series of data gathering and information sharing sessions, along with lawyers asking for specific rules to be implemented in the trial, including preliminary injunctions. Some of these hearings can be called into question later in the pretrial process and overturned, as seen in Apple vs. Samsung and NCSoft vs. Bluehole. And this is according to Cornell law. I'll go through some of these. So the purpose of a pretrial conference in any action, the court may order attorneys and any unrepresented parties to appear for one or more pretrial conferences for such purposes as expediting disposition of the action. So disposition, establishing an early and continuing control, so that establishing the rules, discouraging wasteful pretrial activities, so if stuff isn't needed, they throw it out, improving the quality of the trial through more thorough preparation, and facilitating any settlements. So attendance and matters for consideration at pretrial conference include attendance. A represented party must authorize at least one of its attorneys to make stipulations and admissions about all matters that can reasonably be anticipated for discussion at the pretrial conference. So that means they have to say, okay, if I can't make it, the actual defendant, here are the people I want showing up in my place, right? They've already started that with selecting their attorneys and their lawyers. So now we move on to other matters for consideration, which at a pretrial conference, the court may consider to take appropriate action on the following matters: formulating and simplifying the issues, eliminating frivolous claims or defenses, amending the pleadings if necessary or desirable, obtaining admissions and stipulations about facts and documents to avoid unnecessary proof, and ruling in advance of admissibility of evidence, avoiding unnecessary proof of cumulative evidence, and limiting the use of testimony under Federal Rule of Evidence 702. Don't really need to worry about that right now. But the most important stuff is, if I go down to K, disposing of pending motions, so like a motion for an injunction, that's when this happens in the early case conference. Then if I go down more, the pretrial orders, any conference under this rule, the court should issue an order reciting the action taken. This order controls the course of the action unless the court modifies it. So this is basically saying, once you have all these pretrial orders out of the way, after any conference under this rule, the only way that the order is issued or modified is through the court, right? And that includes an injunction. So all of the injunctions, at least the preliminary injunctions, happen in this early case conference. That's when the lawyers go up and they start asking for their demands, and they say, hey, I want to ban Iron Mace, or hey, I want to ban Nexon, right? It all happens in the ECC. So now that we know what the early case conference is, let's take a look at when it will happen. And according to Cornell Law, again, these guys are, rock stars, one of the best legal schools and legal counsel in the entire country. These guys are pretty much world renowned for their law, at least pertaining to the United States. And the timeline for the early case conference. So the time to issue, the judge must issue the scheduling order as soon as practicable. So, but unless the judge finds a good cause for delay, the judge must issue it within the earlier of 90 days after any defendant has been served with the complaint, or 60 days after any defendant has appeared. So for the Iron Mace versus Nexon case, this means no longer than 90 days after when Iron Mace was officially served, which was 5/30/23 according to the docket, or no longer than 60 days when IM officially appeared, which was 6/16/23, whichever is shorter. That leaves us with a rough estimate of it has to be sometime before August 15th, 2023, at the absolute latest, unless there is a court-ordered emergency, which doesn't happen. It's just not likely. So the absolute latest we'll see the early case conference is August 15th, 2023. However, we do not know the stipulations of the initial extension yet. So it is entirely possible that their extension only lasts 30 days from the date of appearance, which would put the early case conference date somewhere around or before Monday, July 17th, 2023. So the early case conference most likely is going to happen on or before July 27th or July 17th, 2023 in the United States, and that's only because courts don't operate on a Sunday. So the 16th falls on a Sunday, so it's going to be pushed back to the 17th or before. So, but that's the deadline. That's the cutoff. Unless the extension allows for more time than that, but it has to be before August 15th, no matter what. So, what does all this mean, and what's the TLDR? So, this means that it's entirely possible for Iron Mace to go to the early case conference and win their U.S. injunction hearing by 7/17/23, which would allow them to release early access in the United States without any issues from Nexon. In fact, it's highly likely that either no injunction will happen against Iron Mace, or a heavily modified injunction will be put in place that allows Iron Mace to continue operations with Dark and Darker. It is extremely unlikely that Nexon will outright win either the U.S. injunction or hearing or the Korean injunction hearing, let alone both. So, in which case, early access can come out without any issue sometime at the end of July, possibly as soon as July 21st. And the reasoning for this is because the dates are, as I put up here, I might not put it. So the dates are pretty simple. So July 21st is the date for the Korean court case, at least reported date for the Korean court case, and July 17th is the tentative date for the early case conference in the United States. So it can happen before, it can happen a little bit after, but it has to happen. Everything has to be wrapped up by around August 15th, no matter what, even in Korea. So no later than mid-August will we know everything. So in closing, regardless of what happens, we should have more information, including what will happen with Dark and Darker in the long term, by the middle of August at the latest. I hope this video helps clear some stuff up, and if you like what I'm doing here, please consider subscribing to my channel, joining my Discord, and becoming a patron. There are links in the description below. Everything that you can do helps keep this channel going, as well as keeping my dream alive of releasing my own game, because all the money, if any, I get from this is going to go directly into my own game. If you want to see more of this content, please drop a like. If you have any questions, concerns, or just want to yell at me, feel free to let me know what you think in the comments. And I hope you have an awesome rest of your day. I'll see you guys all in the dungeon. Peace.